Thank you, Cathaoirleach Laskin Carla. The bill which I am proposing today is a short and a relatively simple one with a specific purpose in connection with licensed premises and certain private membership clubs. But the importance of this bill is much broader than that. Because the COVID-19 pandemic presents an unprecedented challenge for all of us and for all of our society, the public health restrictions in place since the outset of the pandemic have not been easy for anyone. It has impacted on all of our lives in big ways and indeed small. The vast majority of people and businesses in Ireland have complied with public health restrictions across the last 6 difficult months because they understand that doing so is the most sure way not to just keep us all safe, but also to help us return as quickly as possible to a more open society that we have enjoyed but can no longer take for granted. My firm belief is that this bill will help to bring us further on that road by encouraging the small minority of licensed premises who are acting contrary to public health regulations to bring themselves into compliance, and by providing An Garda Síochána with the powers to act swiftly to enforce the law where necessary. The creation of these powers will further incentivise responsible licensees to ensure full compliance with the public health regulations. As deputies are aware, An Garda Síochána has been carrying out extensive work in support of the range of public health measures since the outset of the pandemic. The graduated policing approach, which has been adopted in all of its actions, whereby Garda members have engaged, they have educated, encouraged and only as a last resort enforced relevant emergency regulations, it has been a very effective one. Since the introduction of Operation Navigation at the start of July, An Garda Síochána has been carrying out regular checks on licensed premises for adherence to COVID-19 public health regulations. Thousands of checks have been carried out, and it is very clear from the Commissioner's public reports on this operation that the vast majority of public licence holders and premises have been acting in compliance with the regulations, and I want to sincerely thank them for that. But the unfortunate reality is that some premises are flouting the law, risking the health of their customers and the wider public. An Garda Síochána has identified that between Friday the 3rd of July and Sunday the 23rd of August, a total of 165 potential breaches were recorded, including a number of licensed premises, of which multiple potential breaches were identified. This represents an unacceptable risk to human life and public health in the context of COVID-19. It also undermines the efforts and the sacrifices made by so many others in our society. And so this bill aims to provide for further enforcement powers required by An Garda Síochána to be able to deal swiftly and effectively with such breaches at licensed premises or certain registered private clubs. I would reassure deputies and indeed the public that I understand and fully expect that the graduated policing approach which we have seen to date will continue to be pursued by Gardaí if this bill is enacted, and I do not expect to see these powers used frequently. But let us also be very clear that this graduated approach depends for its efficiency on a realistic prospect of enforcement at the final stage, and so my firm belief is that providing these additional enforcement powers to Gardaí, we will see an improvement in compliance with COVID regulations by publicans, restaurateurs and operators of private clubs in the interest of public health and in a way that will protect the gradual reopening of our society. In terms of the detail of the bill, I'll outline now the contents to the House. Sections 1 and 2 are standard. They relate to the interpretation and application of the Act to licensed premises and clubs selling or supplying liquor to members or visitors for consumption on the premises. Section 3 provides for entry without a warrant of a member of An Garda Síochána to such a premises for inspection and other purposes under the bill, and creates an offence where a person prevents or obstructs or attempts to prevent or obstruct a Garda from doing so. Sections 4 and 7 set out clearly the new priorities which I am proposing, or the new powers, which I am proposing, and there are 3 of them. Under Section 31A of the Health Act 1947, which was introduced to deal with COVID-19, a member from Garda Síochána can give a direction to a person who, in the Garda's view, is failing to comply with the penal regulation made under that particular section. If the person does not comply with the Garda's direction, they are committing an offence. In addition to the offence under the 1947 Act, these sanctions provide that where a licensed premises fails to comply with directions of An Garda Síochána in relation to the public health regulations, firstly, a Garda member of at least a superintendent rank may make an immediate closure order for a remainder of the day once he or she is satisfied, based on the information provided, that there has been a failure to comply with a direction given and it is appropriate to do so. Secondly, An Garda Síochána may apply to the District Court. This is for an emergency closure order for a period of up to 72 hours or 3 days, where there has been again a failure to comply with more than one direction on more than one occasion. Thirdly, An Garda Síochána may issue a compliance notice to a relevant premises where there has been again a failure to comply with the direction, ordering them to comply forthwith and warning them of the consequences of a failure to comply with that notice. An Garda Síochána may apply to the District Court for a temporary closure order where there has been a failure to comply with that particular compliance notice issue under Section 6, and this failure is likely to continue or to reoccur. This order will be for a period of not more than 7 days in the case of the first order that's made, and not more than 30 days in the case of a second or a subsequent order made in relation to a premises. I wish to state unequivocally that the enforcement measures provided for in these sections may only be taken where a direction of a member of An Garda Síochána has not been complied with. So everybody will be given an opportunity to cooperate and to work with the member of An Garda Síochána, or the member that is engaging with them. This is in line with the approach taken by the Gardaí to date, that is to direct an individual to comply with the regulations in the first instance, and to only take further action where there has been a failure to comply, to come into compliance following that direction. The whole purpose of this provision is to achieve compliance. These sections also create a number of new offences where a person fails to comply with an immediate closure order or permits a business to be opened in contravention of an emergency or a temporary closure order. For the avoidance of any doubt, I want to clearly say that the approach taken in this bill is to provide An Garda Síochána enforcement of criminal law provisions and not public health assessments. The approach taken in these sections is to establish the power for Garda members to make directions, to enforce the penal provisions of the COVID-19 regulations and the offences provided for under this bill and the Health Act of 1947. And Garda Síochána will only need to be satisfied that a relevant provision of the criminal law has been breached, not the likely impact that breach on public, or not the likely impact of that breach on public health. Sections 9 and 10 make provisions for appeals against a compliance notice and a temporary closure order, respectively. This is in addition to provisions allowing an application to be made to discharge an emergency closure order under Section 5 of the bill. In other words, when the emergency closure order is made, the publican or the licensee holder can immediately seek for that to be dismissed. An appeal may be made to the District Court in respect of a compliance notice within 7 days of such a notice being issued by a member. The Court may confirm, it may vary or revoke the notice. Again, any decision by the District Court in this regard can also be appealed to the Circuit Court, adding an extra important safeguard. An appeal may also be made to the Circuit Court against a temporary closure order by the District Court. These are further important safeguards in the bill. Section 11 and 12 provide that conviction of offences under this Act or the making of a closure order under this Act may be a basis for any objection in relation to renewal of licence, or in the case of a private club, a certificate of registration. This bill is closely related to the new health regulations prepared by the Minister for Health, and Section 13 is a necessary amendment of Section 31A of the Health Act 1947. This amendment provides that the Minister for Health may prescribe penal provisions of regulations made under the Health Act 1947 that the provisions of this bill will apply to. He may do so following consultation with me and any other Government Minister as he considers appropriate. Sections 14, 15 and 16 contain necessary technical provisions around liability for offences by bodies corporate, exercise of jurisdiction by the District and the Circuit Court, as well as service of documents. Finally, Lasken Corla, Section 17 is primarily a technical section setting out the title and the operation of the bill. I would, however, particularly draw Deputy's attention to the provisions of Section 17.3, which contains an explicit sunset clause. The section provides that, if enacted, this piece of legislation will continue in operation until only the 9th of November 2020, subject to a resolution approving its continuation passed by both houses of the Oireachtas. This is to reflect the expiry date contained in Part 3 of the Health Act, Preservation and Protection and Other Emergency Measures in Public Interest of 2020. Finally, as I've said at the outset, I believe this is a very straightforward bill. While I fully recognise that the emergency powers that I am proposing are significant, I believe that this bill represents a necessary, a proportionate and a carefully balanced and human rights complaint approach to address the small minority of breaches which have been taking place where we are showing disregard for public health regulations. Clear safeguards have been provided throughout, in particular through the requirement of involvement of a Garda member of at least the superintendent rank, the time-limited nature of the closures and the provision and the possibility of appeal. And none of these provisions can be triggered unless a person fails to comply with the Garda direction in the first instance. Further, and as I have said, the legislation itself is temporary. Gardaí are continuing to take a graduated, a proportionate and a human rights complaint approach to the enforcement of all COVID-related legislation. Providing for these additional limited powers will enable Gardaí to move swiftly to address those cases in which private premises or licensed premises and private clubs breach public health regulations in the context of the grave threat to human life and public health that we are facing. I am confident that this will encourage greater overall compliance and support the hard work and good faith efforts being made by the vast majority of licensed premises to operate within the law. I also want to thank all deputies here today for their support and assistance in passing this through the House and waiving the pre-legislative scrutiny. I commend the bill to the House and I look forward to hearing from deputies on this matter. Thank you.
Thank you, Minister.